Hello, welcome to the self-learning platform by Dr. Sushma Singh. Today we start Unit 7, UN System, Pacific Settlement of Disputes. Introduction about the unit. In a community, if occurrence of violence is to be minimized, if not eliminated, there should exist practices or procedures by which disputes and conflicts that arise from time to time may be resolved. Otherwise, the people involved in them will come to feel that recourse to violence is the only method available to settlement them. Within a state, the legislature resolves major social conflicts by enacting laws. The judiciary settles the disputes between individual members of the community by applying the law. Some disputes, such as those between employers and the labor, are considered as not amenable to settlement by the judiciary, and so they are left to be resolved by collective bargaining between the groups concerned and by procedures such as conciliation. Some are submitted to adjudication also. In the international community, there are only two major non-violent methods available: the diplomatic methods and the adjudicative methods of settlement of disputes. The use of diplomatic and adjudicative methods within the United Nations system forums the subject of this and the next unit. Before we examine the role of the UN system in facilitating the settlement of international disputes, it will be useful to introduce you to the various modes of peaceful settlement disputes as well as the objectives, principles, and functions of the UN. Now, modes of peaceful settlement of disputes. The modes of peaceful or non-violent settlement of international disputes can be broadly divided into two: those marked by direct communications between the concerned parties, and the others where the intermediary or a third party plays a vital role in resolving the issue. The first one is negotiation. Negotiation is directly communication between the parties with a view to reach an agreement concerning mutual claims between the parties. If each party tries to accommodate, in part if not wholly, the claim of the other party, then the parties might be able to arrive at a mutually satisfactory settlement of their respective claims. If either party or both stand firm on their demands, negotiation cannot proceed. A bona fide negotiation requires that each party tries to understand the other party's concerns and accommodate the other latter's demands to the extent possible. The outcome of negotiation may be a settlement of the dispute or no settlement. Negotiation has this feature that each party feels that it is dealing with the other party on a footing of equality. Indeed, the political reality is that often the negotiating parties are unequal. There are in the world community now big powers, small powers, and mini powers. When a big power negotiates with a small power, there is a scope for the former to use its superior position to coerce the latter to accept a particular solution. If the small power feels the impact of such coercion, it may terminate the negotiation. Under international law, there is no obligation for a party to negotiate to settle a dispute unless such an obligation was undertaken under a treaty or agreement. And an obligation to negotiate does not imply a duty to reach an agreement. Negotiations may be on a bilateral basis and also on a multilateral basis. When a large number of states are interested in a particular issue, they may meet at a conference and conduct negotiations to resolve the issue. It is frequently seen in newspapers now reports of conferences concerning various matters. For example, the Third UN Conference on Law of the Sea met from 1973 to 1981 and arrived at a comprehensive treaty on the law of the sea. Conferences or congresses are convened whenever there are a number of issues to be settled by multilateral negotiations. The second is other modes. When negotiations break down, there might be a complete termination of communication between the parties concerning that dispute, unless a third party steps in to revive and promote communication for reaching a settlement. Let us briefly examine the different procedures by which an intermediary may help the parties to reach a settlement. The first is lending good office. A third party interested in the settlement of the dispute may lend its good offices to influence the disputing parties to resume their dialogue. Lending good offices means recommending and encouraging the parties to reach an agreed solution. The next is mediation. In mediation, the intermediary functions more or less as a medium of communication between the parties. Before the First Hague Peace Conference, 1899, the stepping in of a third party to mediate was liable to be considered by the parties to a dispute as an impermissible intervention in their affairs. But the Hague Convention reached at that conference provided that the signatories to that convention had a right to offer good offices or mediation even during the progress of hostilities over a dispute, and such offer should not be regarded as an unfriendly act. The intermediary may promote communication between the parties and help them to settle their dispute. The next is conciliation. In international legal terminology, conciliation differs from mediation in that in the former the intermediary not merely functions as a medium of communication between the parties, but also plays an active role of suggesting to the parties the term of settlement. Even in mediation or extending good offices, the intermediary may play some active role of suggesting to the parties the terms of the settlement. In some conciliation procedures provided under treaties, the procedure of conciliation resembles judicial procedure. The parties are required to state their cases in writing and permitted to make oral presentations, and the conciliation or a body of conciliators recommends a set of terms of settlement. It is then open to the parties either to accept or reject the terms. Unlike in arbitration or judicial settlement, wherein the parties are bound to accept the award or judgment. In mediation or conciliation, the intermediary exercises some power over the parties to the dispute. The intermediary may choose what to communicate to the parties, what to omit, in what language to communicate, and how to time the communication. But the proposals given for settlement may not always be fully impartial, and sometimes may be designated to serve the interest of the intermediary. That is the reason why often parties to a dispute are averse to accepting mediation or conciliation. Without the consent of the parties, neither extending good offices nor mediation nor conciliation is possible. To be successful, the conciliator should possess some skills. First, he should be able to conduct himself in such a manner that he appears to both the parties as quite impartial and objective. Second, he should able to present to the parties different alternatives of settlement out of which the parties may make their choice. There is the possibility that a mediator or conciliator may be so placed that he can offer something in return for what a party is asking to gives up. A good intended big power mediating between two small powers may be able to do that. The World Bank was able to bring about a settlement between India and Pakistan regarding the sharing of Indus waters, offering a big loan for some irrigation projects. Next is inquiry. At the first Hague Peace Conference 1899, this procedure was devised as an alternative to arbitration, so that those who may not be willing to accept arbitration may accept this procedure. In this procedure, the parties agree that the intermediary will investigate the dispute questions of the fact between the parties and give his finding. They may also agree that the intermediary will supply clarifications on questions of law. In the light of such findings and clarifications, the parties may reach an agreement to settle the dispute, or they may reject the findings and clarifications. In the past, this procedure did help to solve some disputes. Next is arbitration. Arbitration as a method of settlement of disputes can be traced back to 600 BC. In the practice of Greek states, it has had a troubled history in the Islamic world. In modern times, the practice developed in a significant way from the second half of the 19th century. The Alabama claims arbitration brought a serious dispute between Great Britain and United States to peaceful settlement. The Hague Convention 1, 1899, adopted at the First Hague Peace Conference, and the Hague Convention 2, adopted at the Second Hague Peace Conference 1907, provided detailed rules concerning international arbitration. During the time of League of Nations, when there were serious discussions to plug the holes in the League system by adopting the triple formula of arbitration, disarmament, and security, the League Assembly recommended to the members the adoption of treaty, the General Act, Pacific Settlement of International Disputes 1928. The General Act provided rules for arbitration. In 1949, the UN General Assembly adopted the revised General Act for Pacific Settlement of International Disputes. This act comes into force among such states as accede to it and become parties. However, as very few states have acceded to it, the effect of the International Law Commission of the UN has resulted only in drafting model rules on international arbitration. The chief characteristics of arbitration are: first, the obligation to submit a arbitration arises from the consent given by the parties. Such consent may be under a special agreement called compromise concerning the particular dispute, or under a treaty provision which requires a particular category of disputes to be submitted to arbitration. Second, the constitution of the arbitration tribunal or its composition is, as agreed to by the parties, unlike a judicial tribunal regarding the composition of which the parties have no choice. Third, the jurisdiction of the arbitral tribunal is limited to what is specifically conferred on it by the agreement, but the tribunal had competence to interpret the agreement and determine its jurisdiction. The judicial tribunal's jurisdiction is as conferred on it by the instrument by which it is established. Fourth, the law and procedure which govern the proceedings before the arbitral tribunal are as agreed to by the parties. In the absence of such an agreement, the tribunal may apply international law and the procedure commonly adopted by arbitral tribunals. The arbitral tribunal is unlike a judicial tribunal. The former applies the law and procedure as prescribed by the instrument by which it is established. The decision given by arbitral tribunal is binding on parties. Usually states do abide by arbitral awards, but sometimes the losing party may set up the plea that the award is a nullity. When such a plea is put forward, the successful party may have to negotiate for a settlement or adopt compulsive measures to secure compliance with the award. Such measures should now be in accord with provisions of the UN Charter. Possibly the successful party may bring the non-compliance of the award before the UN Security Council as a matter threatening international peace and security. The possible grounds on which the plea that an award is a nullity may be put forward are: the agreement to submit to arbitration is itself invalid. The tribunal acted beyond its jurisdiction. The award is not supported by any reasoning or adequate reasoning. The award is vitiated by fraud or corruption on the part of the tribunal. The tribunal committed an essential error or a manifest error of law, as when it fails to apply a clearly governing treaty. Arbitration remains now as a useful alternative to the parties when they do not desire to go to a court but want to abide by a third party decision. The relative flexibility in arbitration, in the choice of the members of the tribunal, and of the law and procedure of the tribunal may provide an attraction to the parties to prefer arbitration to judicial settlement. Next is judicial settlement. Either party to a dispute may approach a judicial tribunal vested with jurisdiction or power to decide the dispute and draw the other party to it. The tribunal decides on the disputed questions of fact, applies the relevant law, and gives its judgment. It is obligatory for the parties to carry out the decision. Now we want to wind up this lecture. Thank you so much for your attention.